Neil Knox, The Gun Rights War. Next section, Unchanging Truths of Gun Control. Page 68, December 28, 1986. The state of New York about a year ago enacted a very drastic firearms law known as the Sullivan Law. This law was intended to stop crime, and statistics show that there's been more crime in the state than ever. Crime conditions even got so bad that enterprising concerns in New York are issuing insurance policies against loss by holdups. The presidents of 7 burglar insurance companies have postponed the state legislature to repeal the Sullivan Law. There's no doubt what that writer would think about New York's law today, almost 3/4 of a century after he wrote that pamphlet concerning revolver legislation. He wrote, "Every little while some legislator or city council presents an ordinance regulating the sale of firearms, thinking such regulation will stop crime. In every instance, it doesn't accomplish the purpose sought. These laws and ordinances only have the effect of stopping the sale of firearms in legitimate channels. If all firearms were put into a furnace and destroyed, it would not be 2 weeks before burglars, hold-up men, or lawless characters would have firearms, thus putting the law-abiding citizens at a disadvantage. No legitimate dealer sells burglar tools, but burglars have them and use them, which is evidence that they cannot be prevented from securing implements necessary to their lawless trade." The writer was absolutely right. He didn't identify himself, but I suspect he was the owner or manager of Fred Biffer and Company of Chicago, which printed the piece. I received a copy of the pamphlet from Dwight Glenn of the Black Hawk Gun and Auto Club, Stratsville, Pennsylvania, who found it in a stack of invoices and letters, all dated 1913, in a long-closed hardware store. We share the frustration of the writer who wrote, "The Second Amendment is plain English language and understood by people who read English, and therefore should be no question as to what it does mean. We believe the legislator may have the right to regulate the carrying of firearms on the person, but not the right to regulate the sale of the same. Law-abiding citizens of the United States should have the right to purchase a firearm to protect home, family, life, property, and liberty." Maybe the writer was just a clerk with Biffer and Company who was determined to protect our gun rights, and maybe he did more than he or we will ever know, plugging a trickle before it became a torrent. When you study your guns, think of him and those like him who have made it possible for us to own firearms. And do your part so law-abiding citizens can enjoy guns years from now. There's an editor's note from his son. Biffer and Company was a distributor of ammunition and firearms that prospered from around the turn of the century to the last century to the Depression. They traded mostly in moderately priced guns with the names like Harrington and Richardson, Ivor Johnson, and Walther, as well as lesser-known marks with the names like New Secret Service, Special, and Ortigius. While researching this piece, I found another Biffer pamphlet, this one a small catalog, apparently from the 1920s. On the back page, there appears an illustration titled "The Unprotected Woman and Child." In the picture, a lone woman with her daughter arms herself against a menacing figure at the window. The accompanying editorial states that revolver laws, rather than hindering criminals, usually seem to prevent or handicap respectable citizens from obtaining a means of home protection. Far from being the scribbles of a lone clerk, Biffer's stance against prohibitive gun laws appears to have been long-standing company policy. Their stand is an example of enlightened self-interest. The guns Biffer sold were not the arms of those who could afford to comply with or safely ignore the Sullivan Law and its ilk. Biffer's affordable but politically incorrect guns, many of which would become known as the racist moniker Saturday Night Specials, were the target of those laws. Congratulations to Biffer and Company for standing up to the threat. would the rest of the firearms industry had been so wise over the past half century. Next section is Second Amendment, avoided, never voided by the courts. From October 9th, 1987, starts on page 71. During this 200th birthday celebration of the U.S. Constitution, there's been much attention to the Bill of Rights, particularly the First Amendment freedoms of press and speech, but almost nothing concerning the Second Amendment right to keep and bear arms. When mentioned at all, the Second Amendment is usually called either a dinosaur or fleetingly kissed off as only applying to National Guard. That is appalling treatment for the section of the Bill of Rights that was intended to guarantee all the other freedoms. Consider what the Supreme Court Justice Story wrote in 1833. The right of the citizen to keep and bear arms has justly been considered as the palladium guardian of the liberties of the Republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers. The Texas Supreme Court put it more bluntly in an 1859 decision: the people cannot be effectively oppressed and enslaved who are not first disarmed. That is precisely the point made by students of government from Plato to Machiavelli to John Locke, all of whose works were familiar to the learned 55 men who gathered at Philadelphia to draft our Constitution 200 years ago. The preeminent legal scholar of the time, Sir William Blackstone, considered the right to keep and bear arms among the absolute rights of free Englishmen. The Second Amendment has nothing to do with hunting, target shooting, gun collecting, or any other recreational use of firearms, except that as they affect your ability to defend yourself and your nation. While in one sense it gives the right and ability to revolt, the beauty of this freedom insurance is so long as the right exists, it need never be used. The weekend that President Nixon fired the special prosecutor investigating his role in the Watergate, I mentioned a pending gun bill to a friend who, while being a gun buff, took a rather liberal political view. He exploded. How can you think about gun control when Nixon is about to padlock the Supreme Court building, roll out the army, and declare himself a dictator? Just what do you think keeps him from doing it? I growled back. My friend looked at me in a speechless astonishment. After a few beats of silence, he said quietly, "Now I understand why you fight gun control. The Founding Fathers would have understood. They fought a bloody revolution when the British tried to take the guns at Concord and powder at Williamsburg." Having overthrown the oppressive government, the delegates to the Constitutional Convention were extremely concerned about reforging chains such as they had just broken. Yet they knew that if their hard-won freedoms were to be preserved, they had to construct a stronger national government than the loose confederation of states that existed. While framing our Constitution, the Convention unanimously rejected a Bill of Rights, for they didn't think one necessary in a government of enumerated powers. But the people refused to accept the new Constitution until its supporters promised that a bill of individual citizens' rights would be proposed by the first Congress. 12 amendments were proposed. Only 10 that guaranteed individual rights were ratified. We are continuously told that the Bill of Rights outlines the fundamental rights of all U.S. citizens, but for well over 100 years, the Supreme Court considered the Constitution as a limitation only upon the laws passed by Congress. Not until this century did the court begin to decide that the Bill of Rights also protected citizens from the state laws infringing speech, religion, and other freedoms. The court has selectively expanded these amendments to apply to the states, virtually all except the Second Amendment, one right at a time. The Second Amendment clearly was intended as an individual right, for it says, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Every time the Constitution uses the phrase "the people," as in the First, Ninth, 10th, and 10th Amendments, it refers to individual rights. When the Constitution's just drafters meant state, They said state. Some had confused the well-regulated militia with the government regulation in colonial times. Well-regulated meant well-disciplined or properly functioning. It referred to both the militia and the guns they were required to provide. The phrase still has the same meaning in relation to firearms, for double-barreled guns are regulated to shoot to the same point of impact. Contrary to the glib dismissals of the Second Amendment that we hear today, the Second Amendment didn't merely authorize the states to have a militia, for that had already been covered in the main body of the Constitution, Article 1, Section 8. However, it is true that some congressmen wanted the Second Amendment to only be collective right rather than an individual right. They lost. During Senate debate on what became the Second Amendment, an amendment was offered to make it read, "The right of the people to keep and bear arms for the common defense." Perhaps it was proposed because there had been an armed rebellion in Massachusetts only 2 years before, or because there was concern about armed criminals and highwaymen even then, but the effort to water down the right to keep and bear arms was soundly rejected. The Second Amendment cannot apply only to the common defense when that limitation was proposed and defeated. As additional evidence that it is an individual right, the first version stated, "No person religiously scrupulous of bearing arms should be compelled or rendered to military service." Or compelled to render military service. Congressman Elbridge Gerry of Massachusetts opposed that phrase, saying this clause would give an opportunity to the people in power to destroy the Constitution itself. They can declare who are those religiously scrupulous and prevent them from bearing arms. Congress was clearly discussing an individual right, for only individuals can be religiously scrupulous. With such clear evidence as to the intent of the Second Amendment, why can't the Supreme Court see it? The short answer is this: they don't want to. According to Justice William O. Douglas, biographer, shortly after his appointment to the Supreme Court, he was told by Chief Justice Hughes, "You must remember one thing. At the constitutional level, where we work, 90% of any decision is emotional. The rational part of us supplies the reasons for supporting our own predilections." What makes that startling admission particularly significant is that Douglas was appointed in the early 1939, the same year the only Second Amendment decision this century was handed down, accepting the National Firearms Act. There have only been 3 significant Supreme Court decisions on the Second Amendment: U.S. versus Krukashak in 1746, Presser versus Illinois in 1886, and United States versus Miller in 1939. Handgun Control, Inc. often quotes from the Krukashak, which says the bearing of arms for lawful purposes is not a guaranteed right by the Constitution. They never quote the next sentence from that decision. Neither is it in any matter dependent on that instrument for its existence. The court stated in the Cruikshank that since the First and Second Amendments limited only Congress, they did not prohibit the Ku Klux Klan from conspiring with local officials to prevent newly freed black slaves from holding political meetings or having guns. It boggles the mind to hear so-called liberals proudly cite the Cruikshank decision. The fact is this: denying guns to freed slaves was the start of the gun control movement and the narrowing of the Second Amendment. Only 19 years before the Cruikshank decision, in the infamous Dred Scott decision, one of the factors leading to the Civil War, the court had ruled that a freed slave was not entitled to the privileges and immunities of citizenship, for that would give the persons of the Negro race full liberty of speech, to hold public meetings upon political affairs, and to keep and carry arms whenever they want. The Oak Park, Illinois chapter of the National Association for the Advancement of Colored People is challenging the handgun ban in that Chicago suburb neighboring Morton Grove, charging that it is being unequally enforced against blacks. Discriminatory enforcement of gun laws against blacks and the non-wealthy has always been the rule, yet the Congressional Black Caucus strongly supports laws that would allow the police, like former Selma, Alabama Chief Bull Connors, to determine who may have guns. What a contrast with the slavery abolished, something Cassius Clay said more than 130 years ago. The pistol and the Bowie knife are to us as sacred as the gown and the pulpit. The trial and the appellate courts upheld the Morton Grove handgun ban, citing the 1886 Presser versus Illinois decision that the Second Amendment is a limitation only upon power of Congress and of the national government, not upon that of the states. The Supreme Court declined to consider the appeal, which technically didn't uphold the Morton Grove law, but it had that effect. If the Supreme Court were consistent, it would have overturned both the Cruikshank and the Presser decisions, citing decisions in this century based on the 14th Amendment. The Supreme Court didn't include the Fourth Amendment protections against unreasonable searches as a protection against state laws until 1961. Justice Hugo Black, who in 1960 wrote that the Second Amendment was an absolute prohibition against congressional infringement, said all the Bill of Rights should be incorporated because of the 14th Amendment. In 1871, only 3 years after the 14th Amendment was ratified, Representative John A. Bingham, who drafted it, said, "The privilege and immunities of a citizen of a state are chiefly defined by the first 8 amendments to the Constitution. The 8 articles never were limitations upon power of the states until made so by the 14th Amendment." But long before the 14th Amendment, the Georgia Supreme Court held that the right to keep and bear arms was not to be tinkered with by any level of government. The right of the people to keep and bear arms shall not be infringed. The right of the whole people, old and young, men and women, boys and not militia only, to keep and bear arms shall not be infringed, curtailed, or broken in upon the slightest degree. Our opinion is that any state or any law, state or federal, is repugnant to the Constitution and void which contravenes this right. The Georgia court distinguished between keeping and bearing. While keeping arms was the absolute right under common law, restrictions were permissible on bearing, which could not be borne for the purpose of terrifying the populace. Similarly, in colonial times, there were restrictions upon the way individuals could use arms. The right to bear arms was never applied to anything other than self-defense weapons. So in answer to one of the sillier arguments of the anti-gunners, no, the Second Amendment doesn't guarantee the right of citizens to own a nuclear weapon. College students are told in supposedly scholarly works like The Meaning of the Constitution that the Second Amendment merely prevents the federal government from disarming members of the National Guard. That's nonsense. Even for that book acknowledges the intent of the Second Amendment was to protect the citizens against unconstitutional usurpation of power by the federal government. The National Guard cannot possibly serve as such a brake upon a tyrannical federal government, for the Guard is part of the U.S. Army and is always subject to the orders of the federal government. Example, in 1957, Arkansas Governor Orville Faubus called out the National Guard to enforce the state's laws segregating Little Rock High School. President Eisenhower immediately placed the Arkansas Guard under federal control and ordered them to support Army paratroopers sent to Little Rock to enforce desegregation ordered by a federal court. Exactly 30 years later, in August 1987, federal court in Minnesota made it clear who commands the National Guard by ruling against the efforts of Minnesota Governor Rudy Perpich to prevent the state's National Guard from being sent to Central America for training. So even if the Second Amendment applied only to the militia, the National Guard is, as the Minnesota court ruled, only part of the militia. What you may not realize is that you are only capable of using a gun. If you are capable of using a gun, you are part of today's militia. Only 4 months after the Constitution was ratified, Congress formally reestablished 2 classes of militia that had existed during the colonial times: those who were formally organized into units and all other able-bodied men 18 to 45. When the National Guard was created in 1903, it specifically did not replace the militia, only added a 3rd category. Both organized and unorganized militias are still recognized in current law. But the total unorganized militia is even broader than the statute, comprising, according to the Supreme Court in Miller versus U.S., all persons physically capable of acting in concert for the common defense. In that 1939 case, the only time the court has ever considered a federal gun law, the Supreme Court did what it usually does when faced with political hot potato. It avoided ruling directly on whether the National Firearms Act is a violation of the Bill of Rights. Instead of addressing constitutional rights of a person, which was the issue at stake, it dealt with the characteristics of a gun. The court evasively stated, in the absence of every evidence, the possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia. We cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is in any part ordinarily military equipment or that its use could contribute to the common defense. The reason there was no evidence, no judicial notice, was there was no one appeared before the court to defend the Second Amendment. Only Justice Department's argument was heard, and it was heard by the same Attorney General who had proposed the law in the first place, Attorney General Homer Cummings, and he told the House committee that because National Firearms Act was based on the government's taxing powers, it did not violate the Second Amendment, but would if it were an outright ban, as is the recently enacted machine gun freeze. Short-barreled, smooth-bore guns have always been used in armies and still are. Moreover, even the narrow standards on which the court decided Miller, the law's prohibition against full automatic arms, was unquestionably unconstitutional. Short-barreled, smooth-barrels guns always been used in armies and still are. However, even by the narrow standards in which the court decided Miller, the law's prohibition against all full automatic firearms was unquestionably unconstitutional, for they were and undeniably a part of the militia amendment or armament. And the law says we're all part of the militia. Although the National Rifle Association had frequently argued that various proposed gun laws had violated the Second Amendment, in 1934, NRE agreed to support the National Firearms Act if handguns were removed from the bill, so they didn't enter the Miller case. In 1982, the Senate Judiciary Subcommittee made an in-depth study of the Second Amendment and issued a lengthy report stating what the Subcommittee on the Constitution uncovered was clear, a long-lost proof that the Second Amendment to our Constitution was intended as an individual right of the American citizen to keep and carry arms in a peaceful manner for protection of himself, his family, and his freedoms. So why were we spending so much time, money, and energy fighting gun laws in the states and in the Congress? Why don't those of us who represent firearms owners simply file a case to make the Supreme Court give a proper interpretation of the Second Amendment? Because no one makes the Supreme Court do anything. We know of 3 cases that may be headed to the Supreme Court, but the court won't hear them unless they want to. And if they hear one, the decision is unlikely to directly address the fundamental question, does the Second Amendment today guarantee an individual right? A proper decision, such as Nunn versus Georgia, would strike down most of the federal gun laws and many state laws. It would cause outrage among the national press and governments that wish to regulate every facet of our existence. The Supreme Court avoids that kind of heat. Courts are political animals. Judges are appointed by politicians with full consideration of their political beliefs, as shown by the purely political fight over the appointment of Judge Robert Bork. So the possibility of a major court-granted relief from the oppressive gun laws is slight, at best. However, that doesn't mean we should quit trying, for failure to defend a right means losing it. Despite what the Constitution says and what those who ratified it intended, the fact is no gun bill in recent history has been defeated, and no gun law has been overturned on the ground that it violates the Second Amendment. While it would be wonderful if the Supreme Court were to wave a magic wand, declare all gun laws unconstitutional, and let us go back to shooting instead of lobbying, we don't expect it to happen. If gun owners are going to obtain significant relief from existing gun laws and prevent additional laws from passing, it is only going to be through the development of judicious exercise of political muscle in the state legislatures and in Congress. Much of this article is based upon the Morton Grove handgun brief prepared under the direction of the late Jim Featherstone, a patriot who served as the head of the NRA ILA's legal division during my watch. Special thanks to Dave Hardy, author of Origins and Development of the Second Amendment, and many other books and articles concerning firearms rights, who reviewed this manuscript and made much appreciated suggestions. Also, thanks to Bob Dowlett, Richard Gardner, and Steve Halbrook, whose pioneering works on Second Amendment were also studied. Then there's an editor's note from his son. More than 2 decades after this piece was written, the right case finally came before the Supreme Court. Neil Knox saw the early verdicts and appeals that led to Heller, but he did not see the final judgment. He would have been gratified by the 9-0 decision, 9-0 decision declaring the right to keep and bear arms to be an individual right. But he knew that a Supreme Court decision would not be the last word in the debate over the Second Amendment. Thank you for supporting our projects. If you'd like to buy us a cup of coffee, check out our Patreon channel.
The guys and gals at gunwebsites.com encourage you to take a CCW class every year, practice at least once a month, and carry every day. Thank you for watching gunwebsites.com.